Your Honor.
Will I still be on probation after I get done with that? For the whole 3 years or? That's really what I had to do.
Mr. Maine.
Yeah.
We'll take a little middle of this.
Sorry. Thank you.
Then you left it to the jurisdiction and
It's meant to. Yeah, each of you, he says. So. Oh, no, there's like 60 in each dorm, but I mean, there's compared to prison standards. From home.
There's some both, I'm sure. Not the day before.
Maybe he's good, like, big thing.
A lot of words submission right there, so I take care of another. Like,
She had dope on her. Did that be the laugh?
it could be.
She don't.
Here.
You're getting over him.
I don't see it. I don't see that.
I'll take it. Maybe I have to go with that. That's your charge with that. Not that interesting. I'll have to go back and look at. She didn't have that. Sure, but yeah. So it did something. They got the house.
Mr. Schmidt, are you ready?
Yes, sir.
All right, who do you have with you?
This is James Buchanan.
All right, court calls. Cause number CR 25-196, State versus James Buchanan for arraignment. Go ahead, Mr. Schmidt.
That's correct, Judge. I have a copy of Mr. Buchanan's indictment. His name is spelled correctly. I think the ordering of the suffixes probably, I don't know if that's just a typo, but it has it listed as James Larry III Buchanan. It's obviously James Larry Buchanan III. So it's a Scrivener's error on at least on the indictment paperwork.
And your Honor, state would move to amend and interlineate that.
No objection.
All right, the court grants the state's oral motion to amend the indictment for the proper ordering of the defendant's name. Court will enter Mr. Buchanan's plea of not guilty into the record, finds he's waived the formal requirements of arraignment, and the court does set this matter for pretrial hearing on March 31st at 1:30. If Mr. Buchanan makes bail, then his hearing will be at 9 a.m.
See something. All right. Usually like that. I don't know, but I'm just crying. I'm just push that top of it. Okay, it's. Yeah. Bridges.
Who's next?
This is Roger Bridges.
All right, this is cause number CR 24-299, State versus Roger Neal Bridges. On the state's motion to revoke, go ahead.
Judge, there is a new felony offense. I think I spoke with Mr. Hartwell the other day, and I think they're still waiting on getting those reports back. It forms the basis of part of this motion to adjudicate. So we're going to ask for another setting on Mr. Bridges.
State.
Yes, Your Honor. We haven't received a case file from the agency yet, so we're waiting on that so that we can view it to see if what's there.
All right, court will reset Mr. Bridges for an additional motion to revoke hearing on April 30th at 1:30.
Yeah. That's just, yeah, the next one. Yeah. Isaac Jenkins.
Who's next?
So Isaac Jenkins.
Cause number CR 24-183, State versus Isaac Anthony Jenkins, motion to revoke. Go ahead.
And Judge, I believe the state was prepared to proceed on a contested today, and I requested that we get an additional setting. I was not prepared to do a contested motion. Mr. Jenkins also has a additional case on the trial docket. And I asked Mr. Hartwell to look at some things on that. That's also alleged in the state's motion. So, you know, we'd ask for an additional setting on this.
Mr. Hartwell.
That's correct, Your Honor. I'll take a look at what I was talking with Mr. Schmidt about, and we can carry this motion.
If the court sets this for final hearing on April 30th, are we in a good position to try the case on that motion to revoke?
From my perspective, the answer is no, Judge. I would resist. Well, I would resist doing the motion to adjudicate probation simply because there is that new offense pending that we are on the trial docket for. I'd prefer to try the new case. Obviously, I'm sure that the court objects to that, and the state probably objects to that as well. But that would be my preference for my client, that we deal with a new offense. Now, on the other hand, if Mr. Hartwell and I review that case again, the new one, and we may be able to come to some sort of resolution or an agreement on how we view that case, in which case we might be able to get them all done at the same time.
All right, court will set Mr. Jenkins for hearing on April 30th. If there's not a resolution for all of his cases, then court will go forward on the motion filed by the state on that date.
So I have an Ezekiel Valencia as well, I believe is in Kaufman County.
Yes, I do show that this is cause number CR 24-81 and CR 24-82. Mr. Valencia is confirmed in Kaufman County custody on sexual assault of a child with offense date of December 30th, 2025. Court will reset Mr. Valencia's case for status on April 30th in each case.
I have a plea on Sean Murphy. Hold down.
All right, court calls cause number CR 22-337, State of Texas versus Sean Padraic Murphy. Mr. Murphy, if you'll raise your right hand, I place you on oath. Sir, do you swear that the testimony that you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, your name is Sean Murphy, is that correct?
Yes.
And Mr. Murphy, are you a United States citizen who reads, writes, and speaks English?
Yes.
I see that you were previously before the court on October 25th of 2022. On that date, you pled guilty to a third-degree felony offense of continuous violence against the family. The court heard the plea agreement in your case, approved it, and sentenced you rather to 6 years confinement in prison and a $2,500 fine. The court then followed the recommendation of the state, suspended that sentence, and placed you on community supervision for 5 years. It's during that period of supervision that the state has filed a motion to revoke your community supervision. They have alleged 4 separate allegations of violations. Have you had enough time to review that document with your attorney, Mr. Richard Schmidt?
Yep.
Do you understand everything that you've read and signed as part of your plea agreement today?
Yes.
And I see that your plea agreement is that you would be pleading true to the allegations in the state's motion. In exchange, the state is recommending that your community supervision be revoked and that you be sentenced to 3 years confinement in prison, along with the balance of your financial obligations, including fines, court costs, and reimbursement fees. And you would receive your credit time that you have spent in jail. How much time is that, Mr. Schmidt?
That's 190 days, Judge.
190. So you would receive 190 days credit towards that sentence. Is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Schmidt, do you believe Mr. Murphy to be competent to enter into this agreement, and that if so, he's doing it intentionally, knowingly, and voluntarily?
Yes, sir.
You've explained to him his rights regarding the case.
Yes, sir.
All right, and does he waive the formal reading of the state's motion?
We do waive, Judge.
And he's pleading true to all 4 counts?
Yes, sir.
All right, Mr. Murphy, how do you plead to counts 1 through 4 as contained in the motion? Are those counts true or not true?
That's true.
And you're pleading true to those counts because what's alleged is in fact true. Is that right?
Yes.
And Mr. Murphy, has anyone threatened you, forced you, or pressured you to plead true to any of these counts?
No.
All right, the court will follow the plea agreement. I'm sorry, the court will take judicial notice of the defendant's judicial confession, finds that all 4 counts are true. The defendant's waiver of rights to plead to true is admitted into evidence. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, the court, finding that the defendant has violated the terms and conditions of his community supervision, hereby revokes his community supervision, finds all 4 counts to be true. Court will follow the plea agreement. The court hereby revokes the community supervision of Sean Drake Murphy, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice, and orders him to pay the balance of his financial obligations. And the court awards him 190 days credit towards the sentence for the time that he spent in jail on this cause. Mr. Murphy, you're hereby remanded to the custody of the sheriff so that he can carry out the terms and conditions of the sentence. Once you are released from prison, if you've not already paid off all of the fines and court costs and fees, you need to report to the Van Zandt County Courthouse and ask for a payment plan or pay them in full. Failure to do so could result in a warrant for your arrest. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir. Step over to be fingerprinting.
Thank you. I believe that's all I have, Judge.
Thank you, Mr. Schmidt.
Yes, sir.
Ms. Tabraham.
Yes, Your Honor.
Ms. Bill is in the waiting room. I'm about to pull her in, but I'm going to sign these plea papers first.
Okay. We're gonna get set up.
Is the okay, where it says jail court interpreter, that's your laptop that you've named, correct?
Yes,
Okay.
sir.
All right, give me just a moment. I'll bring Ms. Bill.
Yes, take.
Good afternoon, Ms. Bills. Good to see you. All right, I'm gonna have you state your name and your license number, and I'm gonna swear you in. Ms. Bill, do you swear that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. All right, this is cause number CR 23-62, State of Texas versus Ivan Molina Hernandez. And Mr. Hernandez is set today on the court's docket. What are we doing today, Mr. Manning?
Yes, Judge. If you recall, I had made an oral request for an investigator on Mr. Molina Hernandez's case back in the last court setting. I located and signed a contract on behalf of Mr. Ivan Molina Hernandez, pending the court's release of funds to hire the investigator. I was later received information from the court that requested a order of the amount. We're requesting $1,000 for the initial retainer. And I have not had a chance to file that order since I received the information from the court necessitating that order to release funds. My understanding from Mr. Wayne is that once we get the funds released, the investigation that I have requested should not take long. So I'd ask for a normal reset on Mr. Molina Hernandez's case.
All right, and the court does grant the motion for funds, and as soon as that order is filed, the court will sign that so that you can engage the services of your investigator. The court will reset Mr. Hernandez's case for April 30th at 2 p.m. April 30th.
Yes. Yes, Judge.
And Mr. Manning, when considering whether or not we're ever going to have, if at all, a contested hearing, if you'll notify the court so that we can make arrangements to have an interpreter, because if it's going to be a contested hearing, we may not be able to use the services, you know, of the likes of Ms. Bill or someone else from the Office of Court Administration. We'll have to hire someone else. So if you think we're going to have a contested hearing or a lengthy hearing that's going to exceed 30 minutes or so, then you'll need to let Ms. Abraham know.
Yes, Judge. My hope is that with this investigation, it will prove dispositive and we will be able to have Mr. Molina Hernandez continue on probation.
Thank you, sir. All right, Ms. Bill, thank you so much for being here. And I think we are through with your services and we really appreciate you. Yes, ma'am. Good to see you.
What? No.
All right, Mr. Manning, you have anyone else you're ready on?
Yes, Judge.
Who would you
Ready
like?
on Miss Ann Carter.
Anne Marie Carter, CR 20-204 on the state's motion to revoke.
Yes, Judge. We received an offer from the state, and my client provided a counter offer to the state. I don't believe we reached an agreement at this point in time, so I asked that we be set for a contested hearing on April 30th.
State.
Yeah, no objection to resetting.
All right, then the court sets Ms. Carter for contested hearing on April 30th at 1:30. Who would you like next?
Next, ready on Mr. Estrada.
Matthew Estrada, CR 20-40. Also on the state's motion to.
Yes, Judge. We've reached an agreement in this case and request it to be set on the March 5th docket for a plea.
All right, court sets Mr. Estrada for plea before the court, March 5th, 1:30.
Thank you, Judge.
Who's next?
Judge, next we're ready on Mr. Maine.
Court calls CR 26-2 and CR 26-3, State versus Douglas Ray, Maine, for arraignment.
Judge, I had an opportunity last Friday to go over the discovery in these two cases. My client's name is spelled correctly. He understands the charge against him. He pleads not guilty and requests to be set on the pretrial docket.
All right, the court does enter Mr. Maine's plea of not guilty into the record in each case, finds that he's waived the formal requirements of arraignment, and the court will set Mr. Maine for pretrial hearing on April 2nd at 1:30. If Mr. Maine makes bail, then his hearing will be at 9 a.m.
Thank you, Judge. Judge, next ready on Miss Catherine Beggs.
Catherine Leanne Beggs, CR 25-30. State's motion to revoke.
Yes, Judge. We reached an agreement with the state to withdraw and amend the conditions of probation on Miss Beggs. The conditions to be amended are 1, court cost. Additionally, there's a term of imprisonment as condition of probation, which will be 70 days with credit for time. 78 days with credit for time served. There is an amendment to include safety as a condition of probation, and then the follow-up to safety with ISP being the next step after successful completion of safety.
All right, and what's the amendment to the court costs?
Court cost.
Is that going to be attorney fees?
Yes, it appears that attorney's fees are $1,000.
So it's an additional 500, I'm assuming.
That's my belief. I don't have a court cost breakdown, but I can read off the court cost listed in her amendment is $280 on court costs, fine the amount of $1,500, attorney's fees in the amount of $1,000 for a total of $2,780.
Ms. Beggs, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Glory again. All right, Ms. Beggs, you heard the agreement that Mr. Manning, your attorney, read to the court. Is that correct?
Yes, sir.
And are you asking the court today to approve upon the state making a motion to withdraw its motion to revoke and to amend your conditions of community supervision to include those things, which is detention and confinement in the substance abuse felony punishment facility known as safety, that's rehab, and the 78 days that you've been in jail you'd be ordered to serve those as a condition, meaning that you would not be entitled to credit for those days in the future should you be revoked. Do you understand that?
Yes, sir.
And you also understand that you're going to incur new attorney fees for the appointment of Mr. Manning and reimbursement to the Van Zandt County taxpayers. You understand that?
Yes, sir.
And this is the agreement that you've made, and that's what you're asking the court to approve. Is that right?
Yes, sir.
Ms. Beggs, has anyone threatened you, forced you, or pressured you to make this agreement?
No, sir.
You have your attorney sitting to your right. Are you pleased with Mr. Manning and the work that he's done?
Yes, sir.
You understand everything that you've read and signed?
Yes, sir.
Do you have any questions about anything before we go further?
No,
Now,
sir.
now would be the time. If you have a question about anything, now would be the time.
Will I only do 6 to 9 months in the program?
I believe that is correct. And if you want to stop, you can talk with Ms. Burns, who's probably there in the courtroom with you. She can tell you more about the terms and conditions of SafeP, but that is my understanding that it's a minimum of 6 to a maximum of 9 months.
Yes, sir.
And then you may have placement in ISP or a possible halfway house or recovery house after that.
Okay.
Okay, but Ms. Burns, if you want to find out more about that before you agree to it, I can give you a few minutes to do so.
May I?
Yes, absolutely.
Judge, next ready on Miss Longoria.
Cause numbers CR 25-256 and CR 26-6, State versus Dixie J. Longoria. Is Miss Longoria pleading today?
Yes, Judge. She pleaded on 2 different cases. A DWI first that was pled by information, CR 26-6, and the previously filed assault on a public servant, CR 25. I don't remember the last digits for that one.
CR 26. Thanks, I believe.
No, that's the one I just said.
Oh, CR 25-256.
56.
All right, I don't see the plea papers.
Where do you live?
I and my client signed the last one at 1:35. And I showed that both of those were successfully sent to wherever they go once we complete them.
Your Honor, Miss Burns is looking.
Okay.
I believe Miss Burns is signing them at this moment.
Always someone.
That's me.
That's who said that? Who said it's me? Is that Karen Burns?
Yes, Your Honor.
That's what it sounded like.
I'll gladly retire.
You will gladly not retire. That is
That-
denied. That is denied.
That microphone is real sensitive.
Very.
I can pick up.
Okay, they're both signed and submitted.
All right, there they are. All right, give me just one. I've got CR 26-6. Hold up. It's 256.
So basically, you can just stop there for a minute. They may decrease the challenge. And then I think typically the reason I do that. Was to go out.
All right, Ms. Longoria, if you will raise your right hand, please. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you. You can lower your hand. Your name is Dixie J. Longoria, is that correct?
Correct.
And Ms. Longoria, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Absolutely.
Do you have any questions about your paperwork, anything that you've read and signed?
No, we went over it.
Mr. Manning, do you believe your client to be competent? And if so, that she's entering into this agreement intentionally, knowingly, and voluntarily after fully understanding her legal rights?
I do believe she's entering into this plea knowingly and voluntarily. I believe she is competent, and I believe that she has been able to assist in the preparation and negotiation of her defense.
All right. Ms. Longoria, in cause number CR 25-256, you are charged with the third-degree felony offense of assault of a public servant. A third-degree felony in the state of Texas has a range of punishment of not less than 2 years in prison or more than 10 years in prison, and you could also be fined up to $10,000. I see the plea agreement in that case is that you would be pleading guilty to that crime, and in exchange, the state would be recommending. And I'm sorry, I don't know if that microphone's super sensitive today, but I'm picking up all the conversations and it's kind of hard to hear. So Ms. Longoria, the plea agreement is that upon you pleading guilty, the state's recommending that the court convict you of the offense, sentence you to 5 years confinement in prison. They're recommending that the court suspend that 5-year sentence and place you on 3 years of community supervision. Also asking the court to assess you a fine of $1,500. In addition, you would be responsible for court costs of $290, restitution of $81.14, and also reimbursement fees of $520. As part of this agreement, the state is also agreeing to not prosecute you on several charges, one being theft of property less than $2,500 with 2 or more previous convictions. Actually, 2 counts of that, and also another count. Actually, no, I think that's just a repeat. So those 2 counts. And so that's in that charge. In your DWI charge, you are charged with a Class B misdemeanor offense of driving while intoxicated. That carries a range of punishment of up to 180 days confinement in the county jail, and you could also be fined up to $2,000. I see the plea agreement is upon you pleading guilty, the state's recommending that the court finds you guilty and assess your punishment at the maximum 180 days in jail, but they're recommending that the court not impose that sentence today, for the court to suspend that sentence and place you on community supervision for a period of 1 year. As part of the agreement, you would be fined $100 for the EMS trauma fine, and you would also have a fine of $3,000, which is the DWI traffic super fine. That would be probated and would only apply if your community supervision or probation was revoked and your conviction becomes final with regard to that. So if you get revoked, that's when that fine would take place. You would also be ordered to pay court costs of $270 and reimbursement fees of $15. Ms. Longoria, do you understand the plea agreements as I've explained them to you?
Yes, I do.
That's your understanding and that's your agreement, is that right?
Yes, Your Honor.
Okay, so at this time I would ask you, how do you plead to assault of a public servant?
Guilty.
How do you plead to driving while intoxicated?
Guilty.
Are you pleading guilty to both those crimes because you are in fact guilty of committing both crimes?
Yes.
And Ms. Longoria, has anyone threatened you, forced you, or pressured you to plead guilty to either crime?
No.
Court does accept the defendant's plea of guilt in each case respectively. Mr. Manning, any objection to the evidence being admitted?
No objection as offered.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything from the state?
Yes, Your Honor, a couple of notes, just because there's a few things going on here. First off, Lieutenant Haley with the Van Zandt County Jail is the victim in CR 25-256. She is supportive of the plea. Regarding the theft cases, the one of the victims is Shoe Sensation here in Canton. All product was returned to them. The other is Duke's Travel Lodge. That's where the restitution is going to be assessed for the product that was not returned to them. Let's see. I think that's everything, Your Honor.
All right, thank you, Mr. Arlo. Mr. Manning, anything from the defense?
And Judge, just in response, that is correct that Lieutenant Haley is in agreement, and both my client and Lieutenant Haley have made amends for the situation that happened. My client was very apologetic when she found out what she had done due to the level of intoxication that she had in her system at that time. And so she apologized and, like I said, made amends with Lieutenant Haley.
Good, I'm glad to hear that. Glad to hear that. Okay, then the court will review the evidence at this time. Right, the court, having reviewed the evidence in each case, finds enough evidence to convict the defendant. Court will follow the recommendation for the plea agreement today. Court hereby convicts Dixie J. Longoria of assault of a public servant. The court assesses punishment at 5 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence, places the defendant on 3 years community supervision, orders the defendant to pay a $1,500 fine, restitution in the amount of $81.14, court costs in the amount of $290, and reimbursement fees in the amount of $520. The court does take into consideration under section 1245 DA unfiled numbers 2025-1135 and 1136, both theft of property with previous convictions. And in cause number CR 26-00006, court, having reviewed the evidence, finds enough evidence to convict the defendant of driving while intoxicated. The court does convict the defendant, assesses punishment at 180 days confinement in the county jail. The court suspends that sentence, places the defendant on 1 year community supervision, orders her to pay a $100 EMS trauma fine. The court imposes a $3,000 DWI traffic super fine. The court will suspend the payment of that fine. And the court also orders her to pay court costs of $270 and reimbursement fees of $15. Ms. Longoria, you're hereby remanded to the custody of the of the probation department, so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with Sergeant Martinez. After that, you'll meet with the probation officers.
Thank you, Your Honor.
You're welcome.
Judge, if I may just have a moment to speak to Ms. Beggs, make sure all her questions are answered. I think we'll be ready to rock.
Absolutely. I'm going to sign these plea papers anyway.
Oh, okay.
All right, we're back on record, CR 25-30, State versus Catherine Leanne Beggs. Ms. Beggs, did you have enough time to get your questions answered?
Yes, sir.
And do you still want to go forward with the agreement?
No, sir.
You do not? Okay, Mr. Manning?
Your Honor, may I call my client?
Yes. So Ms. Beggs, if you raise your right hand. Ma'am, do you
Yes, sir.
swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And you put your hand down, and I'm gonna allow her to be called for the limited purpose of determining whether or not she wishes to accept or reject the offer. Go ahead, Mr.
Thank you, Judge. Ms. Beggs, we met last Friday. That was our most recent meeting to discuss your case situation. Is that correct?
Yes, sir.
And I provided you several different options from which to choose. And I told you the most likely option that was going to be given, which was in fact the option that was given by your probation office and by the state, which was safety. Is that correct?
Yes, sir.
And I explained to you the pros and cons of completing the program at safety, as well as the assistance that would help bring you with your drug problem. And at that point in time, that was something that you expressed you wanted to do. Is that correct?
Yes, sir.
Okay. But here sitting today, you've changed your mind and you don't want to do that, but you've instead asked for a time offer for TDC, and the state has made an offer for TDC that they're willing to do on your case. Is that what you're wanting to accept?
Yes, sir.
Even though I've explained to you that I think safety would be a better option for your
Yes, sir.
situation. Okay. Your Honor, at this time, I passed the witness, and I also asked that we be set on that March 5th docket.
Can we not just go ahead and do the paperwork today?
Your Honor, I don't think we'll be able to get it fully completed today.
What would be the holdup?
I can double check, but I think some of our staff is out today. I haven't checked to see if they're back, but I can look, Your Honor, but I don't know if we'll be able to.
Yeah, if you don't mind checking, I mean, if she's wanting to go, we could send her today and get her out of the jail. So yeah, check for me. And if we can get it done, let's get it done.
Yes.
All right, thank you, Ms. Beggs. You can go back and have a seat. We'll call you back up shortly.
Yes, sir.
Do you have anyone else, Mr. Manning?
I believe that concludes my business this morning, with the exception of Ms. Beggs.
Okay, we'll give the state a few moments and see what kind of information we get.
Yes, Judge.
Ms. Abraham, if you want to go ahead and bring our extradition up, we can go ahead and do that.
Okay.
All right, you are Miss Williams, is that correct?
Yes, sir.
And your first name is Jillian.
Yes,
Also
sir.
correct? All right.
Yes, sir.
All right, Miss Williams, you are being held in our custody here in Van Zandt County on a warrant that has been issued out of the state of Colorado. And you're aware of that, correct?
Yes, sir.
All right. And the purpose of our hearing today is to determine whether or not you want to exercise your right to extradition. And I believe that we have provided you with some documents for you to review and read over. Have you had a chance to read over those?
Yes, sir.
And do you understand what the documents say?
Yes, sir. And I would like to waive.
Okay, so you understand then that you do have the right to request to be extradited, and then a warrant could be requested through the governor's office from the state of Colorado to the state of Texas, and that you would also be appointed an attorney if you could not afford one to ensure that the extradition process was properly followed. You understand your rights with regards to those things?
Yes, sir.
But you're telling me today that you want to waive your right to extradition and voluntarily consent to be returned to the state of Colorado without a governor's warrant.
Yes, sir.
Okay. All right. Very well. Then on that document there, if you'll just sign your election, then the staff will send it back to me. I will sign it, and we will notify the state of Colorado that you are consenting and waiving extradition, and then they will make arrangements to pick you up. If they are not here within a reasonable time of say 30 days, then
Okay.
then you and I will have another hearing. Okay.
Okay,
And if I don't have some kind of update on progress of them making arrangements to pick you up, then at 30 days, if I don't feel like they've done anything to, take possession of you, then I may, grant you a bond and let you
Okay.
out, and then they can figure out how to resolve their case then, okay?
okay,
But I'm gonna hold you over for 30 days, waiting for them, once they're notified to come and get you, okay?
okay. Thank
All
you
right.
so much.
You're welcome. Good luck to you, Ms. Williams. Mr. Hartwell, any update?
Yes, Your Honor. Miss Abney is back. She had a family thing that she had to run to, but she is back, so she'll get on those.
Excellent, excellent. All right, I appreciate it. Okay. All right. Well, the court will stand in recess, and allow y'all to get that paperwork done.
Yes, sir.
All right. Thank you.
Thank you.
And he's on his way to the bench. And they agree. I think he's not much older than me, so watching. He said, yeah, he looks and acts like he walks like he's 65.
How long is the better?
Hey, 'Cause it's not.
That's right. You get nobody else to work for. The commissioners coordinating for it.
Commissioner's court.
$25. Each one.
All right, Mr. Manning, are you and Ms. Beggs ready?
Yes, Judge.
All right, court is on record at cause number CR 25-30, State of Texas versus Catherine Leanne Beggs. Ms. Beggs, if you'll raise your right hand, I'm going to put you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower it. All right, Ms. Beggs, we've discussed some things earlier today on your case, and you've indicated that you wanted to reject the state's initial offer to continue to withdraw the motion to revoke, to continue you on community supervision, and to amend your conditions to include rehab and some days in jail for which you would get credit. And you've indicated today now that you wish to accept the state's alternative offer, which would be confinement, sentencing, and confinement in the Texas Department of Criminal Justice. Is that correct?
Yes, sir.
Okay. All right. And so I want to go over a couple of things. So on April 10th of 2025, you appeared in this court and you pled guilty to hindering apprehension or prosecution of a known felon, a third-degree felony. The court heard the evidence, found that there was enough evidence to convict you, and the court followed a plea agreement that day at your request. The court found that there was enough evidence to find you guilty. However, the court deferred a finding of guilt and placed you on community supervision for a period of 3 years. And that motion was filed, I believe, around December 16th of 2025. And in that motion, the state has alleged 6 separate allegations of violations. Have you had enough time to review that with your attorney, Mr. Manning?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
And do you understand everything that you've read and signed today?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
Mr. Manning, does your client waive the formal reading of the state's motion?
She does, Judge.
She intend to plead true to all 6 counts?
She does.
All right, Ms. Beggs, then I would ask you at this time, how do you plead to counts 1 through 6 as contained in the state's motion? Are those counts true or not true?
True, sir.
Has anyone threatened, forced, or pressured you to plead true to any of those counts?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the court admitting the defendant's waiver of rights of plea of true in evidence?
No objection as offered.
All right, that is admitted and the court takes judicial notice of the defendant's judicial conviction. Anything further from the state?
Your Honor, only that I had filed a motion to withdraw the MTA in anticipation of our earlier agreement. So I would just ask the court to reject that, but nothing further.
Yes, sir, will do. Mr. Manning, how much credit time is your client entitled to on this sentence?
78 days, Judge.
78 days. All right, anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, then based on the evidence before the court finds that defendant Catherine Leanne Beggs has violated the terms and conditions of her community supervision. The court finds all 4 counts to be true. The court hereby adjudicates her guilt, convicts her of hindering apprehension or prosecution of a known felon. The court revokes her community supervision, assesses her punishment at 4 years confinement in the Texas Department of Criminal Justice, and orders her to pay the balance of her financial obligations. The court awards Ms. Beggs 78 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Beggs, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from TDC, if you've not paid off everything you owe, you're ordered to report to the courthouse and ask for a payment plan. Failure to do so could result in an arrest warrant being issued for failure to pay fees. Do you understand that?
Yes, sir.
All right, Ms. Beggs, please step over to be fingerprinted with the sergeant.
Thank you.
All right, thank you, Mr. Manning. Thank you, Mr. Hartwell. Tell Ms. Abney I appreciate her getting the plea papers done today for Ms. Beggs.
Yes, sir.
All right, I'm going to get those signed and I will reject that motion to withdraw, Mr. Hartwell. And I believe that does conclude our afternoon docket. Court is adjourned.
Thank you, sir.
Thank you, appreciate it.